All right. Welcome or welcome back. This session is When Imitation Is Not Flattering, Cultural Appropriation in Trademarks. This session is sponsored by Copy Curious. And quick announcement, I really apologize to everybody. I totally sent an email with totally wrong times. So thank you so much for your patience. I did send out a correction for that. Also, the schedule tab is accurate. So feel free to refer to that because yeah, I was in a better state of mind, I guess, when I created that. Okay, again, my name is Bree Van Til. I am the Director of Education at Alt Legal. I'm also your Master of Ceremonies for Alt Legal Connect. I'm here to try to make your experience amazing. If you have any feedback for me beyond just learn time zones and how to tell time, please just, let me know. Um, all right, other than that, I am going to remind you, don't be a jerk. If you're going to be a jerk, I'm going to kick you out. You're not going to get a refund. It's going to be awful. So make sure that you don't do that. I don't think you will because you guys are really great. Okay, we are offering CLE credit for this session through the state of California, and that also is an elimination of bias credit. However, we have some requirements for you. Number one, I need you to be present during the entire session. So, you need to be here for the entire 70, that is 70 minutes. I need you to take note of the code. So write it down. Don't trust yourself to remember it. Write it down. And when you get a link to the survey, make sure to put that code in there. Don't try to memorize it. The code must be exact. There won't be any spaces in it. So we'll send the survey at the end of the session. You'll also get an email this evening with links to all of those surveys. So you'll put that link or that code in the link in the survey. All right. So this should go without saying, but again, we're a legal tech company. We're not a law firm. We're not giving you legal advice. And the views expressed here are those of our panel. They're really great. They're smart people, but they're not necessarily the views of Alt Legal. Please feel free to continue using the chat. One of my favorite things about Alt Legal Connect is how active that chat is. Continue to talk amongst yourselves. If you have any questions for the panel, put those in the chat, but start that with the word question so that it's easier for us to find those and get those over to the panel. And someone from our team will make sure that they see them. Now, I'm pleased to welcome our panelists, Nicole Gaither, the panel's moderator, and Katherine Belzowski, Angela Grayson, and Keely Herrick. Our moderator, Nicole, is an art enthusiast who is driven to study law after seeing how local rap artists in her community were exploited by industry execs. She focuses her practice on fighting racial inequities in the IP industry. And if after this session you decide you want more information about how to counsel your clients to avoid cultural appropriation in their trademarks, she's generously donated a prize to our raffle to help coach you about it. So make sure to enter to win that prize. All right. Katherine, her title is like an entire sentence, which basically means she focuses on all sorts of legal economic issues for the Navajo Nation's Department of Justice. As part of that role, she helps enforce the Navajo Nation's trademarks, and she'll be talking about that and some appropriation issues there. Um, and finally, Angela is a veteran trademark and patent attorney um, for Precipice IP. Um, she has over 20 years experience, including as a patent attorney for companies like Walmart and Eli Lilly. And she also worked as a patent examiner for the USPTO. But despite her prowess and love for patents, we love her anyway. Keely, I am the absolute worst. I did not actually write an introduction for you. I'm so sorry. I just realized. I'm sorry. Keely, will you introduce yourself? I'm sorry, you guys. This is not how I normally run. I'm sorry.
Well, hi. I'm I'm Keely Herrick.
You're gonna go away now.
I'm a trademark attorney with my own firm located here in Atlanta. I practiced at a big firm in New York for a long time as well. Over 20 years, I've been a trademark attorney the entire time. I love helping people select and protect their brands. We'll leave it at that.
I think I might be having tech problems, of course.
Of course.
Of course. So.
But we hear you, so.
Okay.
Yeah.
Can you all see the slides?
Yes.
Can see the slides. I can't see anybody's faces on the camera, but, I see little green dots and arrows, so I know we're all there.
Okay. All right.
I can see everything.
Perfect,
so I can lead the site for everyone.
Perfect. Then we will get started, and I will imagine that I see the slides in front of me because for some reason there's a menu that will not go away. So welcome you all. Good afternoon. Thank you for joining us for this session entitled, and I have to look at my slides because I can't even see them, When Imitation Is Not Flattering, Cultural Appropriation in Trademarks. So I don't know if someone has control, if you can switch to the next slide. All right, before we get really deep into this, we thought that it would be helpful to provide some recent examples. Thank you. Our friends in the fashion world almost never disappoint in this area. Some say it's a casualty of the global world where brands based in one country and won by people with one understanding of history expand into other countries and view those consumers through their own foreign lens. The truth is that design has always borrowed the symbols of other cultures and taken them out of context, considering them largely as decoration as opposed to a representation of a narrative. Though when they do go into a narrative, it's one that the brand itself is creating, as opposed to the story already told. That one, of course, actually belongs to another group, racial or religious, and is already resonant with meaning. Most are not looking deep enough to understand the historical and cultural context of their design and marketing choices to assess what might be offensive, inappropriate, or simply used without permission. And if we can go to the next slide, please. All right, is someone able to move to the next slide? Can you all still hear me?
Yeah, we can still hear you just fine.
Okay.
Did you want us to go to slide 3 or slide 4?
Can I go to slide 3, please? Sorry. I'm going to probably reload when one of you all is speaking later. All right, so slide 3. Gucci and Prada both brought us things that were a little less than flattering here in this situation. Both were pillared for their decisions to include images that were reminiscent of Sambo characters in their collections. These were from 2017 and 2018. And for some reason, they felt that this was something that should have been fashionable without really realizing the historical context of Sambo in history. Next slide, please. Slide 4.
Hey, Nicole, can I pause you there for a second?
Sure.
I do remember the backlash. I don't know if other panelists remember the backlash, particularly on social media. And there was one rapper out of Atlanta who was particularly put out, I think it was T.I., about in particular the Gucci campaign. And I personally, when I saw this, I could not believe my eyes. And so many people said that they were going to protest this. But you have to wonder, ask yourself, I know this is all about this misappropriation, but you have to wonder if sometimes companies do this for the outrage and for the attention, because so many people have continued to buy Gucci,
Right.
even after that.
Right. Both of them. Like I see people still buying Gucci,
Yeah.
Prada. I mean, if we look at all the luxury fashion houses, I'm sure if we dig deep enough, we will see. And of course, as we go through, you'll actually see some other things where it was just like, what were you considering? What were you thinking? Who was in the room?
Right.
I was going to say, spoiler alert for talking about the Kardashians as well. The
Right.
family who believes that no publicity is bad publicity.
Right.
Yeah.
All right. On to slide 4. So, as I mentioned, fashion keeps giving us these things. We saw cornrows on the Valentino runway and faux locks on Marc Jacobs runway. And it's very interesting, especially since we're seeing these styles that are, normally representative of African American culture, but for some reason they seem to have been placed into a fashion context. When asked about using these particular hairstyles on fashion runways, Marc Jacobs' hairstylist said, as with a fashion show, we look at tons of references. So the look ends up being a result of many different inspirations and cultural references. And he actually noted that his inspiration was from Boy George and Marilyn Manson, 80s club kids, Japanese Harajuku girls, who we'll see more of a little bit later, and ravers. Basically saying that was a melting pot of ideas. But you don't even consider the people who actually, like, if we look at George Clinton, a Parliament Funkadelic. I mean, he wears faux locks that are colored, just like where we see here with the Marc Jacobs. Also Bob Marley. So this, we're crediting some of the wrong people as originators. And then what usually happens there is that it becomes a tangled web of confusion where we just don't even give credit to the people who started the trend or this was a part of their culture. And meanwhile, so
I think that's, well, can I just say this whole idea of credit, because you would say to yourself, well, if I were counseling a business, what are they supposed to do with that? Are they supposed to say, oh, we can't borrow hairstyles from other cultures? How do you make good on that? But I think we saw this whole idea with the people of color on like social media and the choreography, like during the pandemic, not getting credit. And part of it might just be that, if you're going to borrow or be inspired by different cultures for different perspectives in design, do you at least give credit? I mean, the idea that this person would provide a laundry list of styles and people that they reference, but not very many, people of color for his inspiration seems, again, to your point, the idea of not even providing credit.
Right. And I mean, we're very familiar with what's going on currently with Crown Act legislation that's being passed in several states that was not passed by Congress. I mean, this legislation, I don't know if you all are familiar with it, it's the Crown Act or something similar to it, and Crown standing for Creating a Respectful and Open World for Natural Hair. And it's legislation that it's 2023 and still required to protect employees from being discriminated against based on their natural or cultural hairstyles. I mean, so we still have some issues here where it seems like it's fine for it to be on a fashion runway, but I can't wear my normal hairstyle at work without it being a problem.
Right.
All right, so we can advance to slide 5. And like I said, fashion just keeps on giving. I mean, we're seeing a whole lot of costumes, things that really just seem to have been used inappropriately or without credit. And slide 6, please. So recently, because it's also, we had just recently celebrated the Lunar New Year or Chinese New Year. A lot of fashion houses have been using that. Of course, they present the red branding around this, that time of year or this time of year. And then, of course, it's red and gold and like different things that they're borrowing from these cultures. The Lunar New Year was originated from a spring festival in the lunar solar Chinese calendar. And it's observed by a range of East Asian and Southeast Asian cultures, from mainland Chinese to Vietnamese and Korean. It's usually generalized as Chinese New Year or, Lunar New Year. Each one has a unique belief and customs specific to their cultures, and it celebrates the arrival of the new moon and thus a new year, welcoming happiness, health, and prosperity. And then, of course, over the last decade, these commercial entities such as Louis Vuitton and Valentino have been targeting the holiday for marketing purposes, creating, designing, and customizing like special edition Lunar New Year products, such as these little pockets, to monetize off the moment that celebrates good fortune.
Mm-hmm.
So, have they given credit to anyone? Have they acknowledged? Are they at least educating people about these things? It doesn't seem so.
Mm-hmm.
Next slide, please, slide 7. And of course, we would be remiss if we didn't mention some of the classics that have been in, the U.S. that we're pretty much familiar with. We have, Aunt Jemima, the caricature of a Black Mamie type character. After, of course, the racial reckoning of 2020, the company finally changed its logo and the name to the Pearl Milling Company after years of using this caricature of a Black woman stemming from slavery. The company has actually allowed several of its registered marks to cancel, but that has not stopped at least 3 individuals from filing applications for the name for pancake mixes. So they're trying to bring it back on their own for some reason. And again, around the same time, Uncle Ben's Rice changed to Ben's Original. The Cream of Wheat box did away with its Black Chef logo. So we are seeing some changes. It's a shame that it took this long for it to get there after, people have been complaining about these images for years. So there seems to be some changes happening, but it's unfortunate.
It's just so wild.
Right.
That these images have persisted this long.
All right. So we actually have done our introductions for slide 8. So we will go ahead unless someone wants to add anything to their introduction. I am very excited to be able to move forward with moderating this panel with these 3 amazing women. So let's get started. Slide 9. Before we even get started, we first need to understand what exactly is cultural expression. And it's basically expressions of folklore, music, dance, art, designs, especially in this context that we're talking about today, names, signs, and symbols. And they form a part of the identity and heritage of a traditional or indigenous community. Any thoughts on these? Or I know we definitely need to get to the next slide to define what we're really talking about here today. So,
all right, I'll advance you to slide 10.
Thank you. All right. Keely, I will turn this over to you.
Okay. So yeah, just continuing, with our definition here. So what actually does cultural appropriation mean in this context? It's defined as the adoption, usually without acknowledgement, of cultural identity markers from subcultures or minority communities into mainstream culture by people with a relatively privileged status. So, I think what we were talking about earlier, the without acknowledgement part of this, is pretty key. It's not that you can't ever reference, another culture. It's not that that's never possible, but sort of taking it on as your own, and claiming it, And when you come from a relatively privileged status, that's where we get into appropriation issues.
It seems to me, Keely, that the heart of this is also about equity.
Yeah.
Right, and what's fair, and in terms of credit or commercial appropriation, right? There is, at the heart to me of this whole issue, is there is an inequity surrounding it.
Right.
Very true.
And I think, in our world, in the trademark world, it's also the idea of profiting, right? And branding this, and which branding is claiming ownership of, and then making money or getting some advantage off of this. So that also it's not equitable, it's not fair, like you say. It's taking something from someone else, and then making a profit off of it.
Right.
Okay. So yes. So now the sort of I don't know. Is it fun? It's kind of fun to make fun of celebrities always. But
Right.
the sort of concrete examples that that we can all think of is the fashion industry is one thing, but then just celebrities get themselves into trouble in a lot of ways. And back here, yeah.
Hey, Keely,
Uh-huh.
before you jump into that, looks like we've got a question from
Okay.
the audience, probably around some previous slides that Nicole presented. The question is, seems like it would be a lot better to hire models of the particular cultures that designers wish to highlight. The question is, do you think this would be adequate to address the issue? And I know that we've got some conversation about Gwen Stefani and her Juku girls later, but maybe, I don't know if anybody wants to take a stab at that, or if you want to put a pin in it and say, let's talk about that in a few slides.
Let's put a pin in it, because I think we're also going to kind of address why. And again, not saying that it's inappropriate. It's kind of shocking for a lot of people to see, other cultures using or, putting it in fashion, like cornrows, faux locks, like Bantu knots. Because for one, it seems as if, yes, hopefully you are appreciating, but there's also just that case where there's not really credit given to the people who are originating that style, or who wear that style on a regular basis. And so the question just comes down to, like, are you imitating it, or are you seeing how important it is? Are you giving credit where it's due? So for me, I think it's bigger than just having models of all one race to appropriately wear that hairstyle. There has to be more to it.
Real quick, I'm gonna pause us here. I apologize. The audio is just, there's so much feedback.
Oh, okay.
So it's really, really difficult for the audience to hear. I think we have an issue. It looks like somebody may have shared a link or something, because there are only four presenters in here. Anyway, so Nicole, I put your personal link in here. You don't actually show up as a presenter. Can I get you to, because I think what happens is you may have gotten a link from somebody else, and I think that's why the audio is so bad.
Okay.
Can you come in? I put your link in, Nicole, into the chat in here. Do you see that?
No, but I do have the email that you sent me.
I'm going to send it to you right now.
Okay. So I will log out.
Yeah, log out and come right back. Let's see if that fixes this, because it's just so distracting.
Got it.
And it's really, really good content, so I don't want people to miss it.
The best panel ever.
Okay. Yeah, no, it's definitely, it's a wonderful panel. So thank you. All right, so let's try that again and see if that fixes things. The other thing that we'll want to do, especially if we keep hearing this feedback, is if you're not speaking, let's go ahead and have you mute. So you'll have to mute and unmute if you're speaking or not speaking. Let's see here. So it looks like Nicole is out now. Hopefully she'll come back in just a moment. Okay. Okay. Did we just lose Katherine? Oh, you just turned your camera off. Okay.
I'm here.
All right. I was like, no, not that too. Okay. All right. I'm sorry. Let's see here. Okay, Nicole, you're showing up. Just turn on your camera and your mic. And now I actually see your name, which is great. Okay, give us a little bit of audio.
All right. Can you hear me? 1, 2, 3.
Yes.
Okay.
Yes. That's way better. I think you may have been in as Angela. Maybe you shared a link. Those are unique links. And so it was trying to figure out who was Angela. And I think it was, yeah. So maybe you sent it to her. I don't know. Anyway, but yeah, I think we're good. Let's go back. I'll say a brief word. And Sophia, let me know when are we ready? Okay. All right. Thank you so much for your patience, everybody. We are back live. And here's our panel.
All right. Sorry about that. What's life without some technical difficulties to, make your day? So, all right. We were in the middle of discussing our celebrity branding missteps. So,
Slide 11.
Slide 11. Thank you. All right. So we're going to advance to slide 12. All right. Our good friend Michael B. Jordan here pretty much got thrown into the wolves when he partnered with another person to present a rum known as, they decided to use Juve as the name of the rum. Of course, this is something that's very well known in the Caribbean, especially because it is a festival that is held like in Trinidad and Tobago. And this, it's basically a central part of the carnival celebrations. And it's deeply symbolic. It's a pre-dawn event that was introduced by formerly enslaved Africans after emancipation. So Michael and this partner decided they were going to put out this rum known as Juve rum. They advertised it as a tribute to the carnival celebration. However, it did not go over well with the people of Trinidad and Tobago. They felt like they were being used for capitalism and marketing purposes, and that it was very improper for someone who was not of Caribbean descent to be a part of this. So I just checked actually before we started to see if this, because they actually, filed an application for a trademark in connection with this. And this is, that was also part of the uproar. And that application actually just went abandoned last month. So it seems like, Michael might have separated himself from it, but that person who had filed the application, who was his partner in this, still was trying to go ahead with it up until recently.
Which is kind of shocking.
Right.
And actually, there's a question that I think might be good to ask right now. Question is, what kind of credit would you like to see, or do you think is appropriate? So, right, as you mentioned in this case, Michael B. Jordan said, hey, this is a tribute. So obviously he was sort of giving some credit. What kind of credit do you think is appropriate? I think everybody's muted. Yeah.
Oh, you hear me?
Sorry, go ahead.
Okay. There's an acknowledgement of the community that needs to be made. And I think also, working with people in that community as well. If you're going to be using their cultural symbols, then you should be inviting them to come in to what you're doing. So that's that's the acknowledgement and credit that I'm looking for.
And I think also, isn't it, again, it's sort of the step between like talking about, this event and then actually using it as a brand and making money off of it. Like, I think there probably are just some things that it's not going to be received well if you capitalize them.
Right. Oh, I think you're muted, Angela.
Gets pushed pretty sneakily. I think Beyonce does this particularly well. Like with her Lion King album, she ended up, and actually it's not just that. I mean, going back for many albums, she utilizes all sorts of interesting talent from all over the world, different cultures. And one of the things that she does, I think, is provide an audience for, her inspiration. She gives them an opportunity to dance. She gives them an opportunity to sing. She spotlights the talent. She uses the talent in her videos, right? So the money is flowing not just from her, but also to her inspiration. I also think that's a great example in terms of what real credit is all about.
Right. Exactly. All right.
And then there's Kim.
Right.
So Kim Kardashian had put out a brand of she didn't call it shapewear, she called it solution wear. So foundational undergarments that were going to be called kimono, and this again was not received well. People, first of all, were confused, sort of just the general concept of, misusing a term in the trademark world, because there were no kimono style garments included in this range of underwear. She was not making any sort of kimono style robes. So on one level, it was misdescriptive. So it was confusing from that point. But then also, it was just considered culturally insensitive and inappropriate to be taking, this like very significant, Japanese garment and then naming a whole brand of underwear after it. I think we've probably all been in situations I feel like it comes up for me with clients like every few years where they're like, we want to do something with all the flags of the world. Like we want to put them on underwear around the Olympics, or, we want to put them, use them in marketing. So, I think particularly it seems to come up with when you want to use something on underwear, like that's also, it's the context, right? Like
Right.
that's just, not a great way to use somebody else's culture.
Right. It comes off with a level of disrespect.
Yeah.
Because you're not understanding the importance of why this symbol is a part of this culture. And it just was a play on words like, oh, but my name is Kim, so I'm going to go with this.
Right, because she had other Kim formative brands, and the Kardashians love their branding, which is, as a trademark lawyer, I can only appreciate. But so there was a lot of backlash to this. There was the hashtag Kim oh no was trending for a while, and there were like articles in the New York Times about it and everything. And she also had filed a whole family of trademark applications, but due to the reception that this received, she did withdraw them. She abandoned them. So
right. All right. I know we're kind of behind on our schedule, but I'm going to stick, like we're going to go through these. So I'll let you all know if we need to skip any. All right. So Angela, tell us a little about Kim's little sister here.
So true to form, right? Kendall Jenner created or co-created a brand of tequila called 818. And I think 818 was her Calabasas address, I think. I believe. But the brand was also very similar to another brand of tequila. And of course, she says that she was very much involved in developing this tequila, which is being made, I believe, in Mexico. And so the brand was very similar to another brand of tequila. I think it may be 808, I believe. I can't remember exactly. But there was a dispute, and there was also an allegation that she too was misappropriating the identity of the regard to this tequila. Now, to both Kim and Kendall's credit, I think, they listened to the feedback, they listened to the social media outrage. And one of the things that, Kim changed the brand, so that settles that. But what Kendall did, she didn't change her brand per se. But what she did was she got very involved in the community in Mexico. I believe she settled the trademark dispute with the other company, probably for some money. But she hired a lot of people in Mexico, and I believe she was very involved in some community projects. So the idea of bringing the people along in terms of that culture. There was another commercial of her kind of walking through this sea of agave, I think. People were just very put out by it. But her brand is an example of listening to the feedback and actually making changes and bringing the community along and sort of sharing, if you will, some of the wealth and borrowing that cultural identity for a product. Anybody have any other thoughts on this? I think it's a good example of sort of listening to social outrage and doing something about it.
Right.
Does anybody disagree? I don't know.
No, she heard the message and, did something to change and, to figure out, I need to respect this culture.
Right.
So we are going to start moving a little bit faster because I definitely want to make sure that we get to, the cases that have made changes in this area and that are pretty important. And this is why we do need to be paying more attention, along with what obligations we as trademark practitioners have. So, Keely, I will let you take our favorite musician, Gwen Scott.
Our favorite offender of this whole issue.
Oh, Gwen. Yes, I'll go pretty quickly. So yeah, the pictures kind of speak for themselves here. The thing is that this started right back in the 90s when she first came out and she was dating, Tony Kanal, her bandmate, and No Doubt, and she was wearing a bindi. And, so you could say, oh, that was the 90s. We have a different view on things now. We have more of an understanding now. But, if you look here, this is from 2022, where she's got, the locks and she's wearing a dress in the colors of the Jamaican flag in a video. And the sort of, biggest example for her is she had this whole brand, called Harajuku Lovers, was her clothing line. And in her concert, she had these 4 women who, were her Harajuku girls, and she called them Love, Angel, Music, and Baby. She named them that because Lamb was also her fashion brand. So she had, these characters had dolls, they had, the fashion lines. There was a lot of money made off of this branding. And even recently, she just had an article because people have asked her about this. This is not our discovery. Over the years, people have talked to her about it, and sort of again and again, she kind of double and triples down and says that her father worked in Japan when she was young, and so she really likes the culture. But there was an interview with her in Allure recently where she said, "I am Japanese. I just realized it," and it's like, oh no, girl, she just doesn't seem to get it. And Margaret Cho, the comedian at the time when she had the Harajuku girls, she referred to that as, that made her feel as though Gwen was touring around with a minstrel show. I mean, the girls didn't talk, as I recall. The women didn't talk. These women, they were, her group. It was just a little strange. And she can say all she wants that she, just is a fan of the culture and a fan of all these various cultures. But again, when you take the step to then claiming that as your own brand and making money off of it, and then you have these like voiceless women behind you, and you're giving them sort of character names, I think it's hard to argue that it's not appropriating, this other culture. And the point is, she does it kind of again and again. Here she is as a Native American, and so yeah, in the interest of time, I will just say, you can look into Gwen Stefani and cultural appropriation, and there's, any number of articles about why she's a pretty good example of someone who does this, again and again, and doesn't seem to understand why it's problematic.
Yeah, I mean, like you said, right? This article, was last month, I think, or in December, where she doubles down, and it's one thing to say, oh, I'm really inspired by the culture, but then she's like, well, I'm actually Japanese.
Yeah.
What? I mean,
Right,
because my dad worked in Japan. I mean, that's that's too much. That is not the way to do it, folks.
Yeah.
right.
I really like Italy. I'm not Italian. I completely understand it. I've been there a few times. I know a few words, but no, not Italian. So yeah.
So, of course, sports. What's going on there, Angela?
So many crazy things. So what is this? The Washington Redskins and the Cleveland Indians. So these sports franchises continue to offend our Native American community. Just recently, there was an article. Kansas is in the Super Bowl. I'm actually not a sports fan.
Yeah, Kansas City will be in the Super Bowl.
I know it's embarrassing and not American, but I'm not.
The Rihanna concert, you mean? The Rihanna
Right,
concert.
that's what
Yeah, exactly, the Rihanna concert. And right, so with all this attention on Kansas City, there's now this also attention, hey, let's stop the chop. Our Native American community continues to, express how unbelievably offensive these franchises are, and you have this person, in this costume, that's what he regards this as, and I just don't think that people fully appreciate that this is utterly offensive to a whole group of individuals. The Washington Redskins, we've had this whole debate. I mean, gosh, when I was working in DC as a patent examiner 20 years ago, there was this conversation about Washington, should change their branding. And not until the whole idea with, let's see, it was before TAM, the registrations got canceled under disparagement, but then they were reinstated after the TAM case. And I don't think that the TAM case has really done a lot to help in this area. But this is problematic, I personally think. And unfortunately, the law is really not much help in terms of, providing some equity to the communities that are disrespected with regard to brands hijacking their cultural identity for commercial gain.
Yeah. And we're going to talk about TAM in probably less than a minute. So I'm going to go through these slides very quickly. Some of them I will touch on, but there's been issues with what is considered commercial imperialism, with the fact that Asian rice producers feel like they have not been credited or at least acknowledged by companies that are bringing hybrid rices, the varieties that are like, you can't grow basmati in the US. So these companies have created their own versions of it. And of course, given them a name that's very similar to basmati, such as Kasmati or Texmati. So, we're seeing it there. Juneteenth ice cream. This
Bad
did not
idea.
go over well. Like,
No.
This was a bad idea. This was Walmart claiming that they were celebrating the they called it they're celebrating African American culture, emancipation, and enduring hope by offering us ice cream.
Let me sell you some ice cream.
Right. So here's some red velvet ice cream, and congratulations on the emancipation. This was definitely tone deaf on their part, and they were called out as they should have been for trying to capitalize on a holiday by pushing a product that doesn't appear to benefit the Black community in any way, other than probably adding to weight or sugar intake.
Well, and I think again here by putting the TM on it, again, you're claiming ownership of it.
Right.
That's
whereas
true.
I think they also had napkins and plates, like party things like you would have for other holidays. And I think maybe that is, like, correct me if I'm wrong, but I'm thinking that is not in the same category as claiming it as a brand and putting it on ice cream, which is like,
yes,
not a holiday product,
Right.
Agreed. And actually, this is just another great example of how this is not just an issue with the fashion industry. This, we're seeing this on private brands. I don't know the story behind the Texmati rice, but it feels like it's probably some private brand product that showed up somewhere in Texas. And this is, so this is not, these issues are not just in the fashion industry. These are issues, and we'll talk about the tech industry as well a little bit later, but these are not just, designer issues. They permeate.
Right. All right. Let's talk about the tech.
Oh my. So this issue sort of bubbled up for me in my Apple News a few weeks ago. And I was like, really? I mean, in the tech industry, we're dealing with this? So the Apache software controversy, Natives in Tech is a group representing indigenous people in the technology space. And they're calling out the Apache Software Foundation to change their name and logo. Apache is a brand of open source software. And I went to their website just this morning. And as you can see from this slide, they are registered. Apache is registered to the Apache Software Foundation. And by the way, Apache is also, there are 238 or so records on tests, and I would say maybe 20 or so registrations, but they're not the only one. Another high profile company that has a registration on Apache is Harbor Freight. Harbor Freight also has a number of registrations on the brand for cases and hard cases, I think, for use, which I think is very interesting. And essentially what the natives in tech, they're saying is they're calling on the foundation to take necessary steps to essentially, move on from this. It's highly offensive, not just the name Apache, but you also have the logo that's also the feather. So there's clearly a tie in their minds to this community. And the thing that was really interesting, there's a YouTube I think there may be a documentary where the founders talked about how the Apaches were one of the last tribes to be essentially vanquished by the U.S. government in their efforts to win over the West. And so they are, telling the story, they're appropriating this culture in a way that is highly offensive to this community. One of their strategies in terms of getting the company to change, right? So you really can't rely on trademark laws in terms of the disparagement. There's this whole notion that we'll talk about with Tam with regard to free speech, but they're calling on them, hey, why don't you be true to your code of conduct? Their code of conduct talks about being respectful, talks about listening. And Apache responded, hey, you know what? We hear you. We're going to look into this. This is going to take us a little bit of time, and we can't say what we're going to do, but we'll definitely look into it. But I just wanted to share that example that these issues are not just related to the fashion industry. They're related to consumer packaged goods. They're related also now to technology as well.
All right. So we are actually going to talk about, we're going to kind of skip through these slides just in the interest of time. But as you can see, Nike is also guilty. So we're going to talk about Mattel versus TAM. So this was the case that was decided at the U.S. Supreme Court. Under the Lanham Act, the USPTO can refuse to register a trademark if it falls under one of the enumerated categories precluded from registration. The disparagement clause, which governed one such category, allowed a trademark to be refused registration if it consists of or comprises immoral, deceptive, or scandalous matter, or a matter which may disparage or falsely suggest a connection with persons living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. This meant that the USPTO could actually deem a term substantially disparaging, even without a measure of, proving this so. So in 2017, Simon Tam brought this, had this case where he sued the USPTO, and it went all the way up to the Supreme Court. And the court ruled that the Slants, which was the name of his band, that trademark could be registered, by him for the ban. It also held that the disparagement clause of the Lanham Act, which, barred a disparaging term such as slant from being registered, was facially unconstitutional under the First Amendment's free speech clause. And it basically said that trademarks are not government speech and cannot be prohibited simply because the ideas they express may be offensive to some. So let's talk about how important this is. And I see Bree.
That's okay. I'm just coming in to say the code, so I'll give you a second to think about TAM,
Okay.
because we all know that's a really big deal. So the code is, and make sure to write it down, everybody. Please write it down. Don't trust yourself to remember it. The code is 7. Pilfer 3, as in to break in and steal. The number 7. The word pilfer, the number 3. All right. Carry on talking about TAM v. Mattel.
All right. So yes, now that the Supreme Court has ruled that these types of marks can be registered, this has now opened the door for, the things that we're starting to see. Like, for instance, someone brought to my attention, well, this was actually 2018, but so that's like right after TAM. Someone attempted to register Black women for hair accessories, like extensions, and, kept arguing with the USPTO about, well, this is who it's for. It's for Black women. And of course, the application was refused for being merely descriptive of the people who might be using the product, and then also failing to function as a trademark. So that one eventually was abandoned because the person who filed it just couldn't respond to the USPTO to explain why Black women should be owned as a trademark in connection with these hair accessories. Yeah. So, Angela.
Yeah, no, I was just going to say, this case is actually pretty ironic because the Slants wanted, according to the opinion, right, they wanted to reclaim this term from being a disparaging sort of term to, however they wanted to reclaim it for themselves. And they certainly had that opportunity and did that. But I think on the flip side, it actually works against a lot of potential cultures who don't want people claiming and disparaging their brands. It is a victory in the narrow sense. It is a defeat. It is a it is really a step back for the larger community in terms of protecting cultural identity and not having it be used for commercial purposes. So I think it's highly ironic.
Yeah.
I mean, I think it also just shifts the responsibility for deciding what is an appropriate brand to the public from the PTO, right?
Yeah.
Yep, I totally agree.
In a lot of ways, and also in the same way that now if one does clutch one's pearls a little bit when you look at the trademark registry. You never used to see profanity, right? And then now you look through and it's like every word you can imagine people are trying to register as a t-shirt brand, not just with some sort of cultural offensiveness, but just straight out profanity. And the idea being that, well, they can claim this as a brand, but if they put out FU clothing and nobody thinks that's something they want to invest their money in buying, then the brand would fail. And now the responsibility is on consumers, for better or worse. And I think that's that's sort of the question, right? It's up to consumers to not invest their money in something like that.
Right.
Yeah, it goes from being a legal issue to a moral issue.
Yeah,
Exactly.
Yeah.
All right. So now we're going to talk about the Navajo Nation trademarks. And Katherine, you are up.
Thank you. Thank you. Good afternoon, everybody. My name is Katherine Belzowski. I'm an attorney at the Navajo Nation Department of Justice. I am part of a larger department that deals with various legal issues for the Navajo Nation, but my specific department is responsible for advising our Division of Economic Development, which is the division that houses the Navajo Nation's intellectual property department. And just trying to kind of build off some of my excellent co-presenters and their presentation here. You may have heard of a little case called Navajo Nation versus Urban Outfitters, which was brought in the around 2014 in regards to Urban Outfitters' use of the word Navajo. Again, the fashion industry never failing us and coming through. And so the Navajo, the very specific use of the word Navajo. And why was that the issue for us? Because the Navajo Nation currently has over 100 trademarks of the word Navajo registered with the United States Patent and Trademark Office. So we obviously take great care in policing that trademark and making sure that entities that are using it appropriately. Well, they're using it with our consent, I should say. And so that spurred a real development, with the Navajo Nation in regards to their legal interest in intellectual property. And so the intellectual property department was formed after this case, and me, as well as my colleagues, 3 other attorneys, we worked to help that department monitor the Navajo Nation trademarks in a much more proactive way. I would say probably prior to that case, we really relied, and we still rely on our Navajo citizens. There's over 400,000 registered Navajo citizens in the world. And I would not be surprised if there was one on this webinar right now. Navajo citizens are everywhere, all 50 states, multiple countries, and they really help the Navajo Nation help us monitor some of these things that, just being one office. I'm currently based in Window Rock, Arizona, which, if you're familiar with the geography of Arizona, is the very northeast corner. So I may not get out too much, but our Navajo citizens thankfully do, and help us kind of keep tabs on some of these issues. And sometimes I don't have to go far. All I can do is look at the New York Times, which is what the slide currently on the screen is from, or is actually from. This slide is an Instagram, but this original story was brought to our attention because the New York Times, like Style, Arts, something, whatever, ran a article about this particular designer. And it's a designer out of San Diego, a non-native. He's, I would say if you think of San Diego beach person, this is probably what that human encapsulates, to give you an idea. And they ran a piece on these jackets that he was making. He was calling them Navajo bomber jackets. And so that was my Sunday reading. And then my Monday reading was, following up and telling the individual, excuse me, sir, you cannot call this self a Navajo jacket. And it was, the reason I bring this particular example up, not just because I think it kind of goes with a lot of the fashion that we've talked about today on this presentation, but the interesting response, because a lot of times I will say when the Navajo Nation does, reach out to individuals who are using its trademark inappropriately, I would say 90% of the time we do receive very positive responses and people being like, oh, I had no idea, I'm so sorry, I'll change, and they'll on their own just change their product description or whatnot. And that's fine, that's kind of what we're looking for. And I would say this was an interesting one because this was one of the most aggressive pushbacks I've gotten since I started doing these cease and desist communications around 4 years ago. And so, for every excuse I would say was provided to me, from I gave the Navajo Nation money during COVID to this is an appreciation, right? I'm appreciating your culture. And then more aggressive communication towards the end of, you don't really understand your culture. I understand your culture better than you do. And so it's like, it was very impressive. And so I was like, oh, and the description was eventually changed. It took a while for us to get the description changed. But it was changed, but we, still to this day receive, not from the designer himself, but to someone who works for his company, we still receive some very aggressive communication from someone. And it's very interesting because, for Native Americans, I feel a lot of times people want to put Native Americans tags on things as a way of selling stuff, right? You have a Native American rug, jewelry. You go on Etsy and there's 500 white women in Texas who are advertising their Navajo jewelry because it sells. It's a selling point, right? It's something that's going to help you sell your goods. And so, when you force people to kind of walk this back, they can get, most of the time they're fine, but they can get a little aggressive with you. And also this idea of we're helping you out. And to say that, my response is, you're not helping me out at all. And what the Navajo Nation does specifically is they hold their trademarks in trust for their members. So if you're a citizen of the Navajo Nation, you can use the trademark as long as you have what we call a census, a CIB, a certificate of Indian blood, which, another discussion. But as long as you're an enrolled member of the Navajo Nation, you can use the trademark to help you promote your goods, right? So what we try to do in how we manage these trademarks is help promote goods that are actually Native made, because they do sell. And there is a large market and people will pay a lot of money for it. And so helping to weed that out so that, when you are buying that necklace, that Navajo necklace, that it's actually a Navajo design necklace and not, made in China and all. So there's a lot of, the Navajo Nation isn't just doing it as a way because I think there's a whole line of thinking that we've discussed today about cultural appropriation, people taking Navajo culture and using it obviously for their financial benefit. And there's their other side of how can we, prevent that from happening, but at the same time also help provide more economic opportunity for our Navajo citizens to provide a platform where their work can be more easily showcased. And then, the other note for if you work with Native American communities or you have Native American considerations in your IP work, also the Indian Arts and Crafts Act, right? So which this one particular example, I just wanted to briefly say, because I think we're running short on time, is this, not only do we use trademark, we also use the Indian Arts and Crafts Act and how that, we use them both together. We use them both in the Urban Outfitters case, and we use them both just in trying to police all this stuff going out there. And this particular bomber jacket, the reason they told us it could be called Navajo is because it was a Navajo rug. So what this designer was doing is he was taking old antique Navajo rugs and cutting them up and sewing them into jackets. And he's like, well, it's a Navajo rug. And we're like, great, show us the documentation that tells us that a Navajo made this rug. And they're like, well, we just know it's a Navajo rug. and I'm very happy that, you from San Diego who've never been to the Navajo Nation know that this is a Navajo rug, but, can you show me something that says it's a Navajo rug? And so I think there's, and that's another area where we're seeing a lot of people telling us, well, we just know something's Navajo. And so that's another aspect to it. And I promise the last on this is that this really came up too a lot during COVID. I would say that especially our leadership took a very big interest in these issues once COVID hit, because what you saw in COVID is people like to raise money, right? Money for particularly for the Navajo Nation. So people were putting Navajo on their GoFundMe accounts. They were putting the flag on the GoFundMe accounts, our seal on the GoFundMe accounts, government symbols on GoFundMe accounts, which led us to go trademark our seal and our flag, even though they had some common law protections, trying to get that official, that put us over the edge to get that trademark, because, people were raking in millions and millions of dollars to help the Navajo people. And so we had, trying to make that distinction between who's actually affiliated with Navajo Nation or Indian tribe and who's not. And I do just want to highlight that, because, there is a difference between people who are actual citizens of the tribe and people who just are fans of a tribe. And so, taking that into consideration in your practice too on, with the whole Gwen Stefani, is it a fan? Is it someone who, everyone has their Cherokee princess in their heritage, right? Not me, but I know a lot of people like to claim that, well, it's okay because I have my Cherokee grandmother, great grandmother, and she was a princess. But are they actually
always a princess?
Yeah. Yeah. And so, everyone, people are like, oh, you have a Cherokee princess? I was like, no, I do not. Very Polish and very Italian, me and Gwen Stefani. So, but I think that's, there's also a difference between someone who may say they're a descendant, of that particular community versus someone who is actually enrolled and is considered a voting member of the community. So something also when you're working with clients, just to kind of tease out maybe a little bit more. And with that, I'll stop because I don't want to finish.
Yes, we have a few more, but I definitely want us to hit on these last couple of slides. The main one is, of course, what do you, as a trademark practitioner, what are your obligations? And it definitely, making sure that you follow the rules of conduct and you exercise your due diligence. Find out, if your client is coming to you with something that is got your spidey sense up, then maybe that's what you need to find out is what, ask the client what the term means, what do they think it means? Conduct your own research to determine if it is culturally significant, this, and not just a term, maybe there's a symbol that they're using or a design or something like that. And of course, we cannot be afraid to actually stand up to our clients and tell them this is probably not a good idea. And if this is something you want to use, then there's probably an approach that we need to take with it. Especially maybe involving someone from that community in this, product or service or whatever it is that you plan on offering. And then you also have the right to refuse to apply for the registration or, turn down the engagement. So those are, some of the things. And I know we have now 3 minutes, so I'm going to kind of go through and then we'll hopefully have a minute left for questions.
Can I just add, Nicole and Keely and I have presented on this topic, similar topic before. And another thing that we've also encouraged people to do is try and have a diverse team of people looking at potentially problematic registrations. If your view is very myopic and you don't sort of get out culturally, maybe you want to invite people, maybe the people on your legal team or the attorneys that you hire, maybe they should be diverse in terms of background, because they may be a little bit more culturally aware than people in the company or people who are maybe just not as aware of some of these cultural sensitivities.
Right.
Yeah, so just to sort of zoom through our last couple of slides, what do you do? So, I think how do you sort of pitch this to a client? Who might be resistant to listening to something like this? And I think this is just one of, a number of concerns, and sort of things that we talk about with clients that aren't technically, is there a, direct hit in the trademark office that conflicts your mark from being registered? There's a whole family of things that we talk about, and choosing a new brand involves a lot of considerations that aren't strictly under the trademark law umbrella, but they're all things that we talk about. Things like, phrases that can have a meaning in another language that might be, might be not offensive in English, but it might be offensive in another language, and that can get you into trouble. But it might be something that you might be able to register in the trademark office. So, that's sort of outside the typical range. And then there are phrases that can have an undesirable slang association. My example here was like MF as an abbreviation. I had a client that sort of, a long way into the naming process for their new business was like, "Oh, do you know what that means?" And I was like, "Well, yeah, I live in the world, I thought you were just trying to be tough, but so that's what, and then there are other things where just communicating the tone of the product. Sometimes marketing teams get a little try hard. We say they can go like really cute or edgy, and that is also something that we might point out and be like, is this really on brand? So coaching that in with this sort of bucket of considerations. The cultural appreciation is something else to think about. Like what are that's a way you can communicate this to a client who might be resistant. So we start by pointing out concerns, not being afraid to speak up, even though this is not just a likelihood of confusion issue. Giving examples of backlash received for similar uses, both in the USPTO and in the court of public opinion, like things that we've talked about here, that can hit a client in their pocketbook. And so that's a way to communicate, that there are consequences. Suggesting tweaks or alternatives that could convey the desired message without being appropriative. So like we talked about, maybe napkins and plates are okay, but ice cream and branding it, with a TM, not okay. And as with other guidance, give the client all the information that they need to make their decision. So.
Okay.
Sorry.
All right. I don't want to cut you off, but unfortunately we are at time. However, I would love for us to pick this up. I know that there were a lot of questions. I'd like us to pick those up in the post-session discussion. So it's the end, but not the end. So please come and join us in the post-session discussion. Um, you could take 5 minutes or so, 4 minutes now, for 3 minutes for a quick bio break, get a drink of water, and I will see you in the post-session discussion. After the post-session discussion, we will have speed networking, which will be not on this platform, so you won't be Umbrella. You're going to be in Gather Round, the speed networking platform. You will see that link in the schedule if you go to speed networking. That is at 3:25. But I will see everybody. I hope to see all of you, all speakers, but also the entire audience in the post-session discussion in about 3 minutes. So thank you so much, panel. We really appreciate it. It was great to hear from you. I think we all learned a ton from this.
Thank you.
Thank you.
Thanks.